I'm privileged this afternoon to present the nominees, Brooks Cutter, John Parker, Robert Buccola, and Steve Campora. This case for them has been about winning the war of attrition and securing justice for California policyholders against the largest insurance company in the country. It has been the largest homeowners insurance company in the country for over 50 years. It is a corporate behemoth that insures 1 out of every 4 Americans. This case began over a decade ago, 11 years ago. And 11 years ago, a small group of lawyers, tenacious lawyers, and a single homeowner decided to take on this behemoth because of their personal property loss adjustment practices. They were not timid, and they fought. The case started in 2006 when a homeowner lost their home and all of its contents and submitted a claim for personal property loss. They didn't use the form that was provided by State Farm. What they did is they created a spreadsheet, itemized each of the items that were lost, and put in the value that those items had based on their condition. When they submitted it, they got a response from State Farm. The response from State Farm was to significantly discount the claimed amounts without explanation, without any inspection, without any inquiry as to how they arrived at the number that they offered. The practice that State Farm used was called take it or leave it. But this tenacious group of lawyers didn't stop. What they decided to do after an investigation and determination that this was a company-wide practice, what they decided to do is file a class action for declaratory relief, and on behalf of 89,000 victims who were underpaid going back to 2004. There were multiple rounds of demurs that resulted in a demur that was sustained without leave to amend and a trip to the appellate court that took 3 years. They reversed the decision of the trial court, and the Court of Appeals issued a public opinion that stated that indeed the Superior Court had jurisdiction to issue the declaratory relief and determine whether or not State Farm had followed California law in the way that they handled the personal property loss claims, and that the remedy was not just to send it to some appraisal arbitration process. When the case was returned back to the state court, it then got prosecuted for the next 8 years in 2 separate phases. The first phase for declaratory relief was to look at whether or not the methodology and the way that State Farm appraised personal property losses comported with the California law. Second phase dealt with the remedy. So let's talk about the first phase. Now, we talk about sacrifice, we talk about perseverance, we talk about commitment and dedication. Let me submit this for your consideration as to whether or not these outstanding lawyers show the kind of courage and passion that we expect from the consumer attorneys of the state of California. Over 40 motions were either filed or opposed, multiple summary judgment motions, multiple motions to decertify the class, 24 discovery motions and appeals of discovery rulings, multiple writs to the 6th District Court of Appeals, over 24 depositions of State Farm claims representatives, adjusters, and the C-suite, the corporate executives, to establish that these policies were uniform. More than 200,000 documents analyzed and evaluated. Over 300 insureds who had to be interviewed to establish commonality. It would be trite of me to say that State Farm's defense tactics were one of obfuscation, deceit, and outright denial of the most basic facts. And I don't say that lightly, nor am I using hyperbole. I want you to consider that over the course of this case, the court had to issue $26,000 in sanctions against the lawyers who represented State Farm. there were 55 Superior Court hearings over 3 different complex judges, over 12,000 hours of attorney time. It became clear to State Farm that these lawyers were not going to go away by some nuisance settlement. They wanted a finding that the conduct of State Farm was wrongful and one that would last. And they secured that. Through their painstaking hard work and discovery, the team proved at trial that State Farm failed to consider the physical condition of the property that they had valued. They found that State Farm had used a secret depreciation guide that significantly discounted the value of items. And when they provided their offer to its insureds, they provided no explanation of the reasons why or the methodology that was used. The court found that both practices were unlawful and violated California insurance regulations. But it didn't end there. They got that victory, and then they wanted to go to a phase 2. Phase 2 had to deal with how do you fashion the appropriate remedy. Once again, another motion to decertify. Once again, motions to dismiss and to throw out claims of disgorgement. Shortly before that second trial was going to commence, at the end of 2017, the case resolved. But it resolved achieving the goals that these lawyers had set out. 1, 89,000 claim holders were entitled to have their claims reassessed and evaluated to ensure they comported with California law. It took 2 years to have that process completed for these lawyers to ensure that those people who sought to have reassessments were done correctly and got repaid with interest. The second thing that they got is they got a declaration stipulation that reads as follows. The factual findings and legal analysis applicable to State Farm's claims adjustment.
Frank, I'm sorry to say that your 7 minutes is up.
May I say that these people deserve to be honored as trial lawyers of the year, attorneys of the year for the consumers of California, because their result will have an impact for decades ahead for wildfire victims and other losses. Thank you.